If you are an immigrant, a visa holder, or even a green card holder traveling through U.S. airports in 2026, stop what you are doing and watch this. The rules at American airports have changed. TSA checkpoints, Customs and Border Protection, and immigration enforcement are now working together in ways they never did before. And thousands of travelers, legal travelers, are being stopped, questioned, and in some cases, detained or denied entry. This video will tell you exactly who is at risk, what to expect, and how to protect yourself before you ever reach that airport gate. Welcome back to Immigration Radar USA, the channel that keeps you informed, prepared, and protected with the latest U.S. immigration news. I'm your host, and today we are covering one of the most important travel alerts of 2026 for the immigrant community. Over the past several months, there have been significant changes to how U.S. airports screen and process foreign nationals, and even some permanent residents. These changes come from multiple directions. The Transportation Security Administration, or TSA, U.S. Customs and Border Protection, known as CBP, Immigration and Customs Enforcement, known as ICE, and directives flowing from the Department of Homeland Security, or DHS. Everything we are covering today is based on official government sources, publicly reported enforcement actions, and policy updates that are already in effect or rolling out right now in 2026. This is not fear-mongering. This is information you need to travel safely and legally in the United States. Let's get into it. So, what exactly has changed at U.S. airports in 2026? Let me break this down into three major areas. Change. Number 1. Expanded screening of foreign nationals at TSA checkpoints. Traditionally, TSA's job was simple: check for weapons, explosives, and security threats. They were not an immigration enforcement agency. That has shifted. Under updated coordination agreements between TSA and DHS, TSA officers are now flagging travelers whose documents trigger alerts in shared federal databases. This means that if your visa status has a discrepancy, if there is an expired document in the system, or if you are on a watch list, TSA can now hold you at the checkpoint and contact CBP or ICE. This is happening at major international and domestic airports across the country, including JFK, LAX, O'Hare, Miami International, and Dallas-Fort Worth. What does this mean in plain language? Even if you are just catching a domestic flight inside the United States, your immigration documents can now be checked and flagged. Change number 2. Increased secondary inspection at international arrivals. If you are flying into the United States from another country, you already know about the CBP inspection process. But in 2026, the number of travelers being sent to secondary inspection has increased significantly. Secondary inspection is when a CBP officer pulls you aside for a more detailed interview. It can last anywhere from 30 minutes to several hours. During this process, officers can review your travel history, ask detailed questions about your trip and finances, search your phone, laptop, and other electronic devices, review your social media accounts, and in some cases, deny you entry entirely. Who is most likely to be sent to secondary inspection? We will cover that in detail in the next segment. But for now, understand this: secondary inspection is no longer rare. It is becoming a routine experience for many categories of visa holders. Change number 3. Social media and digital screening. This one surprises many people, but it is very real. As of 2026, CBP officers have the authority to request access to your social media accounts and electronic devices at the port of entry. If you refuse, they can deny you entry or detain you for further questioning. Officers are looking for statements that suggest you plan to overstay your visa, any content that shows ties to criminal activity or organizations on federal watch lists, political statements that may raise security concerns under current enforcement priorities, evidence that you misrepresented your purpose of travel on your visa application. This policy is not entirely new, but the frequency and intensity with which it is being applied in 2026 has increased dramatically. Immigration attorneys across the country are reporting a sharp rise in clients being questioned about their social media during airport inspections. Now let's get to the part that matters most to you. Who is actually at risk at U.S. airports in 2026? I want to be very clear. Being at risk does not automatically mean you have done anything wrong. It means you are more likely to face extra scrutiny, delays, or complications during your airport experience. Let's go through each group. Group 1. Visa overstayers, even past ones. If you have ever overstayed a U.S. visa, even years ago, that record is in the federal system. CBP officers can see it the moment they scan your passport. In 2026, even people who later regularized their status or re-entered legally are being questioned more aggressively about past overstays. If this applies to you, be prepared to explain your history clearly and honestly. Do not try to hide it. It will only make things worse. Group 2. Travelers from certain countries. The current administration has expanded the list of countries subject to heightened travel scrutiny. Travelers holding passports from these nations, even if they carry a valid U.S. visa or green card, may face more intensive questioning. These include countries with which the United States has diplomatic tensions or limited information sharing agreements. If you are from one of these nations, I strongly recommend consulting an immigration attorney before traveling internationally and returning to the U.S. Group 3, students and exchange visitors, F1, J1, and M1 visa holders. International students are facing some of the most dramatic changes in 2026. CBP and ICE are paying close attention to whether students are actually enrolled and maintaining their student status. If your SEVIS record, that is the Student and Exchange Visitor Information System, shows any gaps, changes in enrollment, or issues flagged by your school, you could be stopped at the airport. We have seen cases in 2026 of students returning from a spring break trip abroad and being questioned extensively about their academic program, their funding sources, and their future plans in the United States. If you are on an F1 visa, make sure your I-20 is current, your SEVIS record is active, and you carry documentation showing your enrollment status every single time you travel. Group 4. Green card holders with criminal records. Permanent residents, green card holders, often assume they are safe from immigration issues at airports. In most cases, you are correct. But there is one major exception. If you have any criminal record, even a minor offense, even something that was expunged, you may face serious problems at the border. Under current enforcement priorities, CBP officers are checking criminal histories more aggressively, and certain offenses that were previously overlooked can now trigger mandatory referral to ICE for a removal assessment. This is especially important for green card holders who travel internationally. When you re-enter the United States, you are legally treated as seeking admission, which means the full weight of immigration law applies to you at that moment. If you have any criminal history and you are a green card holder who travels, please talk to an immigration lawyer before your next trip. Group 5. People with pending immigration cases. If you currently have a pending immigration case, whether it is a pending green card application, an appeal, or any removal proceedings, traveling internationally is extremely risky right now. Leaving the United States while your case is pending can sometimes be interpreted as abandoning your application, and re-entering can expose you to additional scrutiny that could negatively affect your case. The only way to travel safely in this situation is with explicit written authorization from USCIS, such as an advance parole document, and even then, you should consult an attorney first. Group 6. Travelers with inconsistent travel histories. Finally, if you travel frequently between the U.S. and your home country, or if your travel patterns seem unusual to a CBP officer, for example many short trips that could suggest you are living in the U.S. on a visitor visa, you may be questioned about your intentions. CBP officers are trained to identify people who appear to be living in the United States on non-immigrant visas. If your pattern of travel raises this concern, you may be denied entry. Okay, so now you know who is at risk. Let me give you 5 practical steps you should take before any airport travel in 2026. Number 1. Carry all your documents. Always travel with your visa, your I-94 record, your I-20 if you are a student, your green card, your advance parole if applicable, and any USCIS notices related to your case. Keep both physical and digital copies. Number 2. Know your rights. You have the right to remain silent beyond basic identification. You have the right to speak with an attorney, though CBP does not have to wait for one before questioning you at the border. Know these rights and use them calmly and respectfully. Number 3. Clean up your social media carefully. You do not need to delete your accounts, but be aware that officers may look at your public posts. Anything that could be misinterpreted as intent to overstay or violate your visa terms should be reviewed. Number 4. Do not lie. If a CBP officer asks you a question, answer honestly. Lying to a federal officer is a crime and can result in a permanent bar from the United States. If you do not know the answer, say so. If you need a moment, ask calmly. Number 5. Consult an immigration attorney. If any of the risk categories I described today apply to you, do not guess. Do not rely on what a friend told you or what you read in a forum. Speak to a licensed immigration attorney before you travel. Let me bring it all together for you. In 2026, U.S. airports have become a more active zone of immigration enforcement. TSA, CBP, and ICE are now more coordinated than ever before. Social media screening is real. Secondary inspections are increasing. And certain groups, including students, green card holders with criminal records, visa overstayers, and travelers with pending cases, face a higher level of risk than they did in previous years. But here is the most important thing I want you to take away from this video. Being informed is your best protection. You do not have to be afraid of airports. Millions of immigrants travel through U.S. airports every single week without any problems. But they travel prepared. They carry their documents. They know their rights. They have spoken to an attorney when needed. That is what Immigration Radar USA is here to help you do. Stay informed, stay prepared, and stay protected. If this video helped you, please give it a thumbs up and share it with someone in your community who needs to see this. Every share could help protect someone's future, and if you have questions about your specific situation, drop them in the comments below. We read every single one. Thank you for watching Immigration Radar USA. Subscribe for the latest U.S. immigration updates, and turn on notifications so you never miss a critical alert. Coming up next, can ICE enter your home or workplace in 2026? Know your rights. Watch that video next. It could be the most important 10 minutes of your week. Stay informed, stay safe. See you in the next video.